All right, members of the jury, thank you very much for your patience. I know that I keep telling you that throughout the trial, but I do appreciate your patience. There are times, as you know, when I need to talk to the attorneys about things such as scheduling, and we were trying to figure out, I had a proposal in mind, and I wanted to run it by them first, and we're all on the same page or close to it. So here's what I'm going to do. It's about 5:35 right now, and so I'm going to go ahead and release you for the evening. Tomorrow is an off day because there are a couple of you who are unavailable to be here tomorrow, and so it's an off day for you. So you were not planning on being here tomorrow anyway. I'm going to give you Monday and Tuesday of next week off as well. Please understand that we're not just going to be taking time off ourselves. There are things we have to talk about and work we have to do, and so that's what we're going to be doing. I'm going to have you come back on Wednesday morning at the usual time, 8:40. That seems to work pretty well. I want to remind you about the admonishments that I have been giving you throughout the trial. They continue to apply, and I want to make sure that all of you follow those admonishments. We have completed this part of the proceedings, but as you know, given the some of the verdicts, there is another part of the proceedings that we still have to go through, and so it's important that you continue to abide by all my admonishments. It gets a little trickier now because some of you have been deliberating jurors, and others of you are alternate jurors. So first of all, those of you who are alternates, you now know that you're an alternate, and there may be a temptation that for you to think, well, why should I pay attention? I'm an alternate. Or why should I take this serious? I'm an alternate. And you need to avoid that temptation. You need to resist that temptation and avoid that type of thinking, that type of attitude, because that's problematic. And I know it takes a lot of self-discipline. I know it wasn't easy for those of you who are alternates to be in a room doing nothing related to the case and not being able to talk about the case and just sort of waiting. I know that's hard, but there is still a chance that we may need one or more of you. You know, in football, they have this phrase about, and I hate to use a football analogy, but, you know, they have this phrase that the backup quarterback is one hit away from being the starter. And the reality is that alternates, all of you, are one excusal away from being a deliberating juror. So you need to continue to take this very seriously, please. And you don't know which of you is next in line in terms of the alternates. The other thing is, you're not allowed to talk to each other about the case. It may be tempting for the alternates to want to learn some things about the deliberations. Please resist that temptation. You cannot do that. You're not allowed to do that. Does everyone understand that? And the deliberating jurors, you cannot talk to the alternate jurors about the case. You cannot, and similarly, you cannot talk to the about the case with each other within each group. So, for example, deliberating jurors, you cannot talk about the case with each other. Alternate jurors, you cannot talk about the case with each other. You cannot discuss the case. You cannot talk about the case with each other or with anyone else. That admonishment continues to apply now. Do you understand that? Just so that you know, we're going to take the evidence out of the deliberations room and we're going to put it back in the storage room. And so when you come back on Wednesday of next week, it won't be there anymore. You've finished the deliberations at this juncture, and so there's no, you should not be going through that evidence or looking at it or anything like that. Remember the admonishment that I have been giving you throughout the trial about not forming any opinions? That admonishment applies now with respect to this next stage, with respect to the potential punishment. That's the next question in the proceedings, and as you know, you'll be asked to determine what punishment to impose, and you'll have two options: life imprisonment without the possibility of parole, or a death sentence. Those are the only two options. You cannot start forming opinions about that, and you cannot start deliberating about that or thinking about that, even internally, privately in your own mind, and you cannot talk to each other about the case or about your juror service or juror experience. Does everyone understand that? All the other admonishments I have been giving you apply in terms of do not consult any outside sources in relation to the case. That includes dictionaries, treatises, the internet, legal books, technical books, religious books, scientific books. You cannot consult any outside sources in relation to the case. You cannot obtain any information about the case from any media reports. There's a lot of media coverage of the trial. You have to be extremely careful right now about making sure that you're not hearing or watching or reading or somehow learning any information from a media report. Does everyone understand that? And everyone's nodding their head yes. You cannot talk to the parties, the attorneys, or any other witnesses about anything. You cannot talk to any members of the media about anything. You must wear your juror badge at all times when you're on the courthouse grounds so that people know you're a juror in this trial. If you hear that people are talking about the case, remove yourself from that location immediately. And if, despite your best efforts, you inadvertently hear something about the case, let my staff know that you need to talk to me. Does everyone understand that? Yes. All right. Do not permit anyone else to discuss the case with you. I know how difficult this is because when you go home, there may be family members or friends or acquaintances or co-workers, whatever it may be, and they may be curious to want to know what happened or to want to know something about the case, and you cannot talk about the case. You have to stop them, and you have to ask them not to talk to you about the case and not to ask you any questions. The only thing you can tell people is you're on a jury in Arapahoe County, and we anticipate that the trial will be completed no later than sometime in August. That's all you can tell people. All right? Does that make sense to everyone? All right. Let me check my list and see if there's anything else that I want to tell you about. When we reconvene, you will receive additional evidence to consider and instructions on the law that you must follow in making your decision in this next stage of the proceedings. Any decision you make regarding the penalty or the punishment must be reserved until the evidence is completed and you have received the legal instructions that you must follow. And I talked to you before, or actually it was during jury selection, that this next step in the proceedings has up to 3 possible phases, and that you'll be deliberating at the end of phase 1, and then whether we proceed to phase 2 or not depends on what decisions you make at the end of phase 1. If there is a phase 2, then you'll deliberate again, and then whether there is a phase 3 or not depends on your decisions after deliberations at the end of phase 2. And then if there is a phase 3, you will deliberate at the end of phase 3 again, and that's when you'll decide what appropriate punishment or sentence you think should be imposed. But at each point, I'm going to be giving you instructions of law, and at each point, you're going to be hearing evidence and information, and you have to make your decisions following all my instructions of law and based on the evidence and the information presented here in the courtroom. Does everybody understand that? All right. Okay, with that then, folks, I'm going to go ahead and adjourn for the day. At least I'm going to release you for the day. The attorneys and I will talk for a little bit longer, and I'm going to have you come back Wednesday, July 22nd at 8:40. All right? Thank you very much. Get some rest, and I'll see you on Wednesday. Thank you. Please be seated, everyone. The record should reflect that all the jurors have exited the courtroom now. All right. The plan is that we'll take tomorrow off, or at least from being in the courtroom, and that we will reconvene the attorneys and the court on Monday, and so that we can talk about instructions and any other legal issues that we need to discuss before we start. Let's plan to start on Monday at 9, okay, 9 in the morning. On Tuesday, for those of you who weren't at the bench conference, I have granted the defense's request for videotaped deposition testimony for one witness. And so that will take place on Tuesday, and we will start at 8:30 on Tuesday. So plan on that for Tuesday. And then on Wednesday, we'll start, it's my plan that we will start then with phase 1 of the sentencing hearing at the usual time, 8:40 in the morning. All right? Any questions or anything we need to talk about on behalf of the people at this time?
Not about that. I have one other issue, but not about that, Your Honor.
Okay. Anything about that we need to talk about on behalf of the defense, or anything else that you want to say with respect to that?
I will plan on submitting as many proposed penalty instructions as I can for the court tomorrow. Is the court planning on discussing the instructions for all 3 phases on Monday, or how should I plan for that? It occurs to me that we will probably have to have at least one other conversation at some point during the penalty phase.
That occurred to me as well. I at least want to get the introductory comments or instructions finalized, and the instructions for phase 1 finalized, because I think phase 1 will be short based on what the attorneys have represented, and I think it'll go fairly fast, and it's my expectation that we will have the jury deliberating at the end of phase 1 on Wednesday, given what the attorneys have said. So on Wednesday, the jury can deliberate, and then we'll see how we proceed from that. So I want to at least finalize that much, and then maybe talk about a little bit about the other phases in case they happen maybe along the way later on. Does that make sense? Okay, and everybody's saying yes. All right, hold on a second, Mr. Orman. All right, my staff is going to distribute a notice that's notice C-214, and also it occurred to me that you should have copies of all the juror questions and the court's responses. I know you have copies of the juror questions during deliberations, but I don't think you have copies of the final responses that I sent back with my signature on them. So I've asked my staff to make copies for both parties, and so you're going to get that right now. Ms. Gerlings, and I thought that notice C-214 had been distributed already. I'm sorry about that, but I'll give you a chance to review it. All right, Mr. Orman, what else do we need to talk about?
Your Honor, and I'm not asking for a resolution of this today, but it occurred to me that we should at least be thinking about how the court is going to want to address sentencing on the counts of attempted murder and the count of the explosive device, because obviously that is separate apart from the penalty phase sentencing hearing the jury is going to be take part in, but there does have to be sentencing for those counts. The counts that are subject to the Victims' Bill of Rights, which are all but one, the victims of those counts will have the right to address the court regarding what they think the sentence should be. And I don't know if the defense is going to want to present any evidence on that. I don't know if the defense is going to want a PSI. I don't know if the court's going to want to try to do this right away or schedule this off at some point in time. But I think we do need to have that discussion. I'd rather not wait until the end of any sentencing trial, simply so that we can start, at least have the victims who are subject to that portion of the sentencing have some idea of what's going to happen. Because right now, if they ask us, we really can't tell them.
Okay. Ms. Brady, do you have a position on that?
Can we discuss that and get back to the court on that part?
Yes. I'll tell you that my preference is not to proceed on that yet. I think it makes sense to have a plan in place, and to the extent that anyone wants to request a PSI, then perhaps you can let me know that now or soon, but I'm not intending to do anything with respect to that until we finalize the sentencing hearing. I think we owe it to the jurors to focus our energy and our attention on the sentencing hearing and go from there.
I can tell the court we're not requesting a PSI.
Okay, are the people requesting a PSI? Okay, and I don't need a PSI unless someone thinks that it's required by any of the counts, and I don't believe it is. So unless someone looks it up and finds that it's a requirement, I have plenty of information in this case, and more than in any other case ever that I've ever done. So I don't need it. All right, and I suspect that I'll have even more as we go through this next phase or next part of the proceedings. Anything else, Mr. Orman?
No, Your Honor, thank you.
Ms. Brady?
Judge, I was just going to ask the court if we should or can have some witnesses, mitigation witnesses available for Wednesday afternoon. I really believe that perhaps the jury could get past phase one in the morning, and we could start with mitigation witnesses if necessary Wednesday afternoon.
If that helps the schedule for your witnesses, I don't have a problem doing that, but that then means that we also have to finalize on Monday whatever introductory remarks I may have for mitigation. And frankly, there may not be any, because I'm going to address that at the beginning of the sentencing hearing. But I don't have a problem with that, as long as you also understand that we may need to take a day off later on down the line if you run out of witnesses and you still have a witness who needs to testify Monday, August 3rd, for example. And so do the people have any problem with that? Starting with this, or potentially starting with phase two on Wednesday afternoon?
Have a problem with that, Your Honor. I think at some point, and I'm not asking that the defense have this idea today, I would like to just see if we can get an idea of exactly how many days they think it's going to take, because we may or may not want to bring in rebuttal witnesses, and all of those witnesses would be coming in from the eastern part of the country. So we'd have to fly them in and make arrangements, and it's not something we can do, like just have them drive across town.
So yours are flying from the west and theirs are flying from the east.
And we're
You
meeting
can't
in
even
the middle.
agree on that. Yeah. Okay. All right. Well, you should talk to each other. As usual, I'm going to ask that you confer with each other. You folks have been very professional throughout, and you've been communicating with each other well, and I appreciate that. And I'm going to ask that continue so that everybody can make plans. But Ms. Brady, in response to your question, yes, you can have witnesses potentially available on Wednesday afternoon in the event that we're done early by that time with phase one and we're ready to go with phase two.
And I'll check with our witnesses and see if that works out, and I'll let everyone know if it doesn't.
You've mentioned through Ms. Higgs in the past that your witnesses are having some issues in terms of scheduling and that kind of thing. And so I'm going to be as flexible as I possibly can. That's not only for you, that's for the prosecution too, that's for both sides. So I'll work with you. So if it helps you to have some of those witnesses begin on Wednesday afternoon, we'll do that.
Thank
Okay?
you.
All right. Is there anything else on behalf of the prosecution at this time?
No, Your Honor, thank you.
All right. Ms. Brady, is there anything else on behalf of the defense at this time?
No, sir.
All right, and the defendant is being held without bond, correct?
Yes, Your Honor.
Okay, so I don't need to take any action with respect to bond, is that correct?
I think by statute he has to be held without bail.
Okay, there's no change there. All right, thanks everyone. I'll see you folks on Monday. Thank you. The court will be in recess.